Honorable Dr. Justice S. Mimlaji, Honorable Mr. Justice P.N. Prakashji, Dr. A. Tyagarajanji, Senior Advocate, Navi Sir, Balu Sir, Mr. Vijay Kumarji. It has always been a matter of great pleasure for me to be a part of the seminars which are aimed at spreading the legal awareness, be it about cybercrime or be it about the electronic evidence. Balu sir has always been relentlessly pursuing this goal. Navi sir has always been guiding, and we are blessed to have legal luminaries with us. Today, I will talk about section 63, subsection 2 of the Bharatiya Saksh Adhiniyam. It is equivalent to section 65B of Indian Evidence Act, the section 63 now. In section 63.2, we talk about the requirements which make an electronic evidence admissible. I will take some few examples, and with these examples and these practical life things, we will try to understand section 63, subsection 2, and then we will go to the legal language if required. So, we'll take some real life examples and try to understand with a lawyer's point of view. So, how electronic evidence will be produced, what should be the level of proof, and how a lawyer who is opposite counsel is going to challenge the electronic evidence. If we think like a lawyer, we will be able to understand this topic properly. So, for example, your client comes to you and says, "Sir, I have a voice recording in my phone. I want to produce it in the court." It's an electronic evidence. If a client comes to you and says, "Sir, a website has an advertisement which is aimed at cheating people at large. I want to file a criminal case." So that advertisement on the website is an electronic evidence. Someone has a WhatsApp chat which proves that a person is defaming another person. The person who is defamed wants to file a civil suit. So he has to produce that WhatsApp chat. It would be an electronic evidence. CCTV is recording footages and it captures a crime, then that CCTV footage is an electronic evidence. So overall, this is the electronic evidence which is usually coming into use. Emails, WhatsApp chat, voice record, video record, etc. In crimes, mobile tower location is a electronic evidence which is collected by police. So there may be various types of electronic evidence, but generally we will come across these kinds. So when electronic evidence is to be produced before the court, there are two options. Number one, the original device which contains the electronic evidence, that original device itself is produced before the court. But this method is not very practical because your client may be using the laptop in his daily use and the electronic evidence is in his laptop. It may not be feasible for him to submit the laptop with the court. Even the police stations, police personals may not be inclined to, take a responsibility of keeping the original articles, original devices in the malkhana, in the store. So there may be practical problems. Therefore, we have to, instead of submitting the entire device before the court, we have to submit it in some form. So while we store the information which is contained in a device, and when we store it from the device to something else like a compact disc, like a pen drive, and then we submit that compact disc sorry, or the pen drive before the court, this process, or we submit the printout of the chat before the court. So this is a process where we are making the court believe that what we are submitting is original. We are submitting a printout. The printout is as it is of the chat which is in the mobile. We are submitting a video. The video is as it is, as it was recorded in the CCTV. We are submitting the voice recording. The voice recording is, as it was recorded in the mobile phone. We want to convince the court. So the parameters are laid in section 63.2. The certificate is to be furnished in 63.4, and Mr. Vijay Kumar ji will talk about 63.4. But in that certificate which will be furnished in 63.4, there are few parameters which are to be stated in that certificate, and those parameters are provided in section 63.2 of the Bharatiya Saksh Adhiniyam. So let's talk with an example. The simplest example would be a client comes to you and says, sir, there was an advertisement on a website. It is defrauding me. It has defrauded me and it is cheating public at large. I want to file a criminal case. Definitely you would need you need to present that content of the website before the court. Now how to do it? The simplest way is to take the screenshot of the website and submit the printout before the court. This is the simplest way. Or to take the screenshot in your mobile and then submit the printout with the court or with the police. In both ways you would need a certificate under section 63 Bharatiya Saksh Adhiniyam. Only then that printout would become admissible in evidence. So let's talk of a situation where client comes to you and he says, I saw this website in my computer. It has a advertisement which is apparently defrauding people. So you will tell your client, okay, take the printout. Your client takes the printout and you submit the printout before the court. Now, as a counsel for the complainant side, our duty is to ensure that the printout that we furnish before the court, it fulfills all the requirements which are provided under section 63.2, because I am talking about only 63.2. Other requirements will be talked about by other learned speakers. So what we will do, we will furnish a certificate, and as per 63.2, your client will have to state before the court and in the certificate that I saw this website on my computer, I took the screenshot, that screenshot was saved in my computer, and then I took the printout. Now what are the requirements of 63.2? There are 4 requirements. To easily remember it, the shortcut is UFOR. UFO is very often used word, which is very curious, which is very interesting also. So you have to remember UFOR. U means the device in which the information was contained, stored, was used properly. So U. Then comes F. F means fed, that the information was fed regularly in the device. Then comes O. O means operating properly. So the device was properly operational. There was no defect which could hamper the evidence. So there is no such operational problem which can affect the accuracy of the evidence which you are producing. And then comes R. R means reproduced. Means you would say before the court that I have reproduced the contents as it is. So if a chat is in the mobile, the printout is as it is of the original chat. There has been no tampering. So UFOR, use, fed, operating properly, and reproduce. First thing is you have to identify the device regarding which you are satisfying the court with these 4 parameters. So in this example which I gave, the device was computer. You took the printout. So you have to satisfy the code with these four parameters in respect of that computer. Let's take second example. And I will include an element of mistake in this example to understand how the things work in the code. Suppose a client saw a website in his mobile, or a client has a chat or message in his mobile. He wants to file a case regarding that website, advertisement, or chat or email. So he takes the printout, relevant printout. He takes the screenshot in the mobile and then he takes the printout. And in the certificate, he certifies that this chat is contained in my mobile. I took the screenshots and then I took the printout, and here is the printout. Now in this line which I just said, if you pay attention, you would notice there might be a missing link, because the person is saying in the code that the screenshots are saved in my mobile and I took the printout. The question comes that how from a mobile the printout was directly taken, and it may be answered also. But suppose that person has a very normal printer. The printer does not have Bluetooth, does not have Wi-Fi in it. So how will you take a printout using that old technology printer? How will you use that printer to take out printout directly from your mobile? It is not possible. So first, the screenshots from the mobile would be required to be saved in a desktop. Then that desktop through a cable would be connected to the printer, and then the printout would be taken. So the proper channel would be two devices. First, mobile in which screenshots were taken. Second, computer in which these screenshots were saved, and then the printout was taken. So the correct way to furnish the information before the court under section 63(2) would be to tell the devices, both the devices, tell about both the devices. And opposite counsel will, as a defense counsel or as a opposite counsel, the counsel would make an attempt to somehow bring this fact to the notice of the court that one or two devices have been missing out from the certificate. So we have to be very careful. The best way is when a client comes to you and he tells you that electronic evidence is required to be produced, the best way is to first write down the number of devices which are actually involved in taking the output. So for example, if we talk about a call recording, a person comes to you and says that I have a call recording in which a person has threatened me and I want to file a case. That call recording is in his mobile. It is not a very easy thing to directly take the voice recording from the mobile into a compact disc and produce that compact disc before the court, or to take the voice recording from the mobile directly into a pen drive and to produce the pen drive before the court. It is not easy. Means I have never done it. Directly I have never done it. What you would be required is that the voice recording would be first transferred from your mobile to a computer, and then from that computer, by using a software, that voice recording will go into a portable device. It may be a pen drive or a CD, and then that CD or pen drive will be produced before the court. Now in this entire process, just suppose the person who came to you is an old man who is not tech savvy, who is from a rural background. it would be a difficult situation. Because if you take the risk that we will make a certificate, we will, means this old man will furnish a certificate in the court saying that this voice recording is in my mobile and I transferred it into this pen drive and this pen drive is before the court. The opposite counsel will ask him that how did you transfer this audio call recording directly from your mobile to the pen drive? And it will be a very difficult question to answer because there is no answer to it, because in between a computer was involved. So if he furnishes a certificate that the voice recording was in my mobile, I transferred it into a computer, and then from the computer I transferred it into a pen drive. Here is the pen drive which has the call recording. Then the opposite counsel will again ask him that how did you transfer it from the mobile to the computer? How did you store the call recording into the pen drive using the computer? It will be a very difficult situation to answer, no? Here comes the need of an expert. When there is a situation, I have used the word old man. It was not intended to say a generalization that old men may not be tech savvy. It was not the purpose. The purpose was to identify witnesses who are not very tech savvy. They may be anyone. So any person who is not tech savvy, it would be very difficult for him to produce the electronic evidence before the court and to certify it as per the requirement of section 63. More so when it comes to a call recording. So what would be the approach? Means we have to think about it. So if we go with this approach that we engage an expert and that expert helps in taking the audio call recording from the mobile and storing it into a CD or a pen drive, then that expert has to be brought before the court. Then that expert has to depose before the court that I did this process. I know that my computer was used properly. It was under my lawful control. I was storing the information properly. My computer was properly operational, and it was not affected to an extent which would affect the accuracy of the file which I have produced before the court. And he has to also satisfy the court that he has reproduced the audio file as it is without any tampering in it. So that role of expert would be crucial in such situation. So when a person comes to you whose electronic evidence is to be produced before the court, we have to think, we have to first make the list of the devices, and we have to think under whose control these devices are, and the certificate of only those persons under whose direct control, lawful control those devices are, that person's certificate is to be furnished before the court. There may be a situation, in this example itself, suppose there is a man who is not tech savvy, he has a call recording in his mobile, then there is an expert who saved the call recording in his computer, and then he generated he stored the call recording into a pen drive. So there are two devices, and both the devices are under control of two different people. The mobile, which was initially used to record the call recording, is under the control of the old man. Then the computer, which is used to transfer the file from the mobile to a pen drive, is under the control of an expert. So there are two devices, two experts. Now the question is, will we furnish two certificates under 63? We have to think about it. Because if we just go with the old man, how would he depose about the four parameters in respect of the computer? And if we just go with the expert, how would if we just go with the expert, then the opposite counsel would ask him, okay, you are saying that you have correctly transferred the file from your computer into a pen drive. But isn't it true that the original audio file is in a mobile which is not under your control? And the expert will have to say, yes, I do not have any control over the mobile in which the original audio file is contained, is stored. So that may create a problem that the expert is not able to depose regarding the mobile of the old man. So my advice would be to keep things as simple as possible. The devices which are stated in the affidavit or the certificate, we must try that the devices are under the control of single person. And when an expert is required, the expert must be experienced person who has the experience of standing as a witness before the court, who can certify and depose about the devices in use. This is another example, and I will also take example of video footages which are recorded in CCTV. So a CCTV which has a hard drive, CCTV records the video, it is stored in a hard drive, and then from the hard drive a CD is made, and either by connecting it through a computer the CD is made, or maybe directly also, depending on the technology, which kind of CCTV you are using. But overall thing is that in those CCTV recordings also, you must check that from the recording till the making of the CD, the devices remain under the control of the person who is producing them. And if you are taking help of an expert, then expert must clearly state that which devices were under his control. There may be a situation that where the CCTV is recording a footage and there is no hard drive. The CCTV is recording the footage into a cloud, and the person has to download it from the cloud into a computer, then make a CD, and then furnish the CD before the court, and also satisfy the court with all the 4 parameters which are stated in section 63(2). So I will also discuss one very short cross examination which I conducted upon a witness. There was a witness who came to the court and he submitted 2 pages of a website from website Ministry of Corporate Affairs. So the 2 pages he submitted before the court, and I read his 65B. He said that the files were downloaded into my laptop and my laptop was functioning well, and I took the printout as it is. So I asked him that your certificate nowhere mentions, and your affidavit also nowhere mentions the format in which the file was stored in your laptop. And I just thought he would say, yes, I have not mentioned it, but the format was PDF. I was expecting this answer. But what did he say? He said that, yes, I have not mentioned the format because I never downloaded the pages. And I wanted this answer only. So I asked him, so the files, the printouts which you have taken, these files are not in your laptop? He said no. He said that when you open the MCA website, you are not required to download the file. You can simply give the printout option and the printout will come. Here is the issue. When something is not saved in your device, how can you say that this printout is of a file which is saved in my device and my device is functioning well and I have reproduced it well? If your device is not coming into play, if that witness, what that witness was saying, that he has not downloaded the file, it means where is the original file? The original file is in the server of MCA, and he is saying that he simply took the printout from the website. So he is saying essentially that he has a printout, the original of which is in the server of MCA, the original of which is not in his computer. That was my argument. Unfortunately, these things were not discussed in the final judgment. It happens many times, but not an issue. So my advice in short about 63(2) would be to check the person who is going to certify has control over all the devices or not, and if there is any confusion, please engage an expert. He would help you. Thank you so much for having me here, and I wish you a very